I support modifying the current cash bail system that we have here in Wyandotte County. I think that there is a step-by-step process that needs to take place for bond reform. And I think one of the first priorities here in Wyandotte County is revising our current practices to ensure that nonviolent, low-level offenders are not held in jail. Because a lot of times now you have people on low-level felonies that are likely presumptive probation, and they sit in jail for long enough where they're forced into a position where they have to choose between their rights to maintain their innocence and getting back to their job, their family, and those type of things. And losing employment and housing for low-level offenders who are incarcerated makes it very difficult for those charged individuals to overcome barriers once they get out of jail, and it actually increases their risk of recidivism. So one of the first steps I would take as district attorney in Wyandotte County is to create a bond schedule so we can start ensuring that these low-level offenders are not held just because they can't pay. And then the second thing that would also do is make sure that every similarly situated individual is receiving a consistent recommendation for bond, because that's something that's not happening now, and we need to get there to make sure. That's just a start to make sure we're doing things fairly. And a practice like that, and also expediting those low-level cases, will help curb incarcerating individuals on those low-level offenses, and I think that's very important. Okay. I do think, though, that high-level violent felonies, we need to maintain a cash bond system there now. If the legislature changes that moving forward, because I know there's some discussion of that, then we'll reassess at that point.
I truly believe that the cash bail system has disproportionately affected people of color, people who are poor. And because of that, we have to either completely get rid of it or do some strong reform to it. There has to be some modification. And the reasoning is because it doesn't make us safer. The reality is the statute indicates that you are supposed to utilize bail for two reasons. One, to make sure that individuals are going to come back to court, and two, to make sure that they're not a harm to our community. What we find now in the use of the bail system across the country is that people who have money versus people who don't get out of jail, and the ones who have the funds are out while the poor person is sitting in custody. I think that's a huge problem. When you look at the crime that was committed or alleged to have been committed, you have someone whose parents have $500,000 versus the individual whose parent has $500 in the bank, and both of them get a $50,000 cash bond. Well, we know who's going to get out and who's going to stay in. And I think it affects really the case, because that individual who's stuck in custody is less likely to be able to meet with his lawyer as much, who's less likely to be able to get on the side that he needs to get on concerning researching his case and meeting and finding witnesses and evidence and so on and so forth, while the person who has some money gets out and gets to meet with his lawyer and research and prepare. And I think that ultimately that does not make our community safe, and it doesn't make the system fair. So I agree that we need to either get rid of cash bail altogether, or there needs to be some strong modifications to it. I'll tell you that I do not like one size fit all anything. And I think that mandatory minimums is something that was birthed out of a time where it was the politically convenient thing for prosecutors as well as politicians to say they're tough on crime. And with that, then we created this one size fit all. And so hence birthed the mandatory minimums. I believe that there has to be in-depth study concerning those, because here's the fact: it disproportionately affects certain individuals when it comes down to the bottom line. And when any law disproportionately affects any group, over the other, I think that that's a problem and it needs to be changed. I believe that judges are elected as well as appointed, and they have a job to do. And I don't think that removing complete discretion from the judges to determine what those sentences should be are effective to the extent that I believe it's fair and just for everyone. We can go back in history and see how it negatively affected African Americans specifically. When you're looking at the crack cocaine epidemic in the 80s and 90s, where you mandatory minimums concerning crack versus cocaine, you were given life sentences versus cocaine, which is of course the more, if you will, rich folks type of drugs. You would oftentimes simply get probation. And it's those type of mandatory minimums that causes disproportionality, and it was utilized and continues to be utilized in certain areas in a negative way. And so I think it definitely needs to be changed, and it has to be researched to figure out what is the best way to make sure whatever laws we come up with affects everyone fairly.
I don't. I think each and every case has unique facts and circumstances, both from the perspective of the victim and their family, and also from the offender. And a mandatory minimum sentence usually has the potential to force either an unjust outcome or sort of push the boundaries of plea agreements. And what happens is either you have charges that are dismissed, or a defendant ends up taking a plea to something that's not necessarily factually accurate. And I have also seen on the Missouri side, where there's mandatory minimums, those charges just often end up dismissed, just because the facts don't necessarily fit what the legislature has decided should be the mandatory minimum. I'm most interested in advocating for is a community-led crime reduction strategy, which focuses on targeting violent criminals in the community, but also building community relationships. I think that true crime reduction efforts start with community engagement. I think something that we historically have not done a good job of here is bringing community members to the table and asking them what's driving crime in their community. What does their community need? Oftentimes, law enforcement and prosecutors like to sit there and tell the community what they should think or what they should do versus engaging them. So this type of model brings together community members, leaders, prosecutors, and law enforcement alongside service providers, educators, businesses, and other stakeholders to create more of a holistic approach towards reducing violent crime, but also it focuses on building community wealth. And establishing partnerships to move forward together. And what that brings into the table is service providers for mental health services, housing services, employment services. And those are some of the things that are missing in the big picture now. They exist, but they don't collaborate in the same way that we could collaborate with law enforcement and prosecutors. I think an engaged community, historically, if you look across the country, engaged communities are much more likely to report crime and participate in the court process, which is essential to hold offenders accountable and ultimately reduce crime. I also think we need to focus a lot more on youth engagement and create access to restorative justice options for young offenders who violate the law, rather than just making them a felon. I think we need to work towards turning their lives around, helping them with restorative justice instead of, some of the traditional manners of handling those cases, which ends up with financial burdens for parents and, a criminal history for a young offender. I think we can do better. And I think the outcome in using those type of programs will overall make our communities safer.
We'll continue to do what we have done, and that is making sure that we focus not only on prosecution and being reactive, but being proactive. One of the things that this administration did when we got into office was look at the underlying issues, looking at cases holistically, being smart on crime versus, again, the whole one size fits all thought process, lock them up, lock them up. We know that 40% of the people who are in our county jails, not just here in Wyandotte County, but across the country, are dealing with some type of mental health diagnosis. And so so one of the things that we focused in on is working with the district court. We created a mental health court known here in Wyandotte County as the Behavioral Health Court. We also created a mental health diversion program in our office so that we can look at those underlying issues and where individuals are coming into the criminal justice system because of their diagnosis, because they did not have the funds to get the treatment or the help that they need. We deal with that and connect them with the resources that we have. Likewise, we reconnected with the drug court here in Wyandotte County. The previous administration refused to be engaged with the drug court, again, because many traditional prosecutors have that thought process of being tough on crime, and that thought process fails to deal with the underlying concerns. And many of our folks who are in custody are dealing with those addictions and those problems. And so we engage with the drug court. We'll continue to do that. Moreover, we also engage with the community. We created a community liaison board where demographics from all over the county now come together on a quarterly basis to speak with me and my office and engage in how we can continue to fight crime in this community. And that's from the community members to the faith leaders. And then, of course, we also created the BOLD Initiative, which is a youth mentoring program for our young people. And so we are in the schools. We've been into over 200 different youth and neighborhood organizational events to educate the community and mentoring them and what they can do and how they can do it. We want our young people here in our community to see the district attorney's office and the criminal justice system as something that they can engage in and one day become the DA, one day become the judge, and not see themselves as the defendant. I think it's important if you're looking at public safety and crime. Yes, we have to lock the knuckleheads up. Yes, we have to go hard as much as we can on those based off of the facts and the evidence, but simply being reactive is not going to solve the problem. We have to be proactive. And when they get out of custody, those that we send away, we have to engage those who are re-entering, which is what we've done with our expungement program, creating an expungement fair where hundreds of people were able to come and get their records expunged so that they can have an opportunity to be a part of the tax base rather than a tax burden, and become employed, gainfully employed, because gainful employment usually prevents people from committing crimes, specifically of theft. And so those are the things that we have done, and those are the things that we will continue to do to fight crime and to make sure that our community is completely engaged. Criminal justice reform, to me, looks like what we have done and will continue to do. It is sad that George Floyd's death had to occur for some people to accept the realities that criminal justice reform was needed. When this administration came into office in our county for decades, officer-involved shootings was investigated by the same agencies who was involved in the shooting. Those deaths were investigated by those same officers, and it gave an appearance of impropriety. And one of the things we fought for was that, as the Obama administration in the 21st century best practices state, that an outside agency, an independent agency, should come in and to do those investigations, because it builds community trust. It shows the community that it's not home cooking, it's not corruption. But for decades, that's what one of our main agencies was doing here. And so we fought with that. And ultimately now we have someone who comes in, an independent agency who does those investigations. Before we started here, it was not about looking at those post convictions in a holistic way. In fact, the traditional thought process was once a conviction is done, your job is done. And so anyone who says that they're wrongfully convicted, you simply object on procedural grounds and do everything you can not to get them in front of a judge. Well, we got in and we created the Conviction Integrity Unit, and that was sprung on by the Lamont McIntyre case of a young man who was in custody in my hometown county for 23 years in prison for 2 murders that he didn't commit. And ultimately, the Attorney General said, look, he's innocent, and he received his certificate of innocence. But the previous administration, including the young lady who's now running for this position, who was in that office and in that administration, refused to look at that case, refused to let his innocence be known, and they fought tooth and nails. Well, we got in here, we looked at the case, and we said, we're not going to allow procedural bars to stop true innocence. Let's look at the facts. Let's look if he received all of his constitutional due process rights, and we found that it was not. And so ultimately, we dismissed that case. That young man then was released. We then birthed the Conviction Integrity Unit, which is the first ever in the state of Kansas, which now looks at wrongful convictions and look at those cases. Even if we have the ability to procedurally stop them, we are not focused on being loyal to this thought process of, well, my colleague didn't make a mistake or my predecessor didn't make mistakes. We have to continue to focus on what is just and what is right. And that's real criminal justice reform. That's what we've done before George Floyd, and that's what we will continue to do. And in fact, have expanded the Conviction Integrity Unit to a Community Integrity Unit, where now complaints from the community concerning law enforcement, as it is right now and as it was, if you have a complaint against a law enforcement officer, you're told to go to that law enforcement officer. And if we're talking about community trust and appearance of impropriety, well, if I have a problem with that agency, I don't want to go to that agency. And again, best practices says you shouldn't. So we've expanded our Conviction Integrity Unit to include additional law enforcement agents who can now investigate those community complaints. And it has a bilingual hotline as well as an English hotline where community members do not have to be afraid if it's going to be home cooking or if it's going to be dealt with, if anyone's going to do anything. But we are now an independent investigative agency who can deal with these complaints. Those are real reforms that we have done before George Floyd and will continue to do after George Floyd.
I think the death of George Floyd had a lot more to do with police tactics than actual justice reform, but it's definitely reignited that conversation, which I think is really important. Mm-hmm. One of the main things that I think is a day-to-day change that can happen, and one of the first things that needs to happen for justice reform, is to ensure that everyone who comes into contact with the justice system in Wyandotte County is treated consistently in comparison to others who are similarly situated. Case outcomes and case charging decisions should always be fair, and they shouldn't depend on the prosecutor that reviews a case or the person who ends up handling it in court. And it also shouldn't depend on how much money a person has to retain an attorney. Because we've often seen the people who have money and can afford a high dollar attorney get a different outcome from someone who has an appointed attorney. And that's just not the way that it should be from a policy standpoint from the district attorney's office. I think it's also really important to make sure that we maintain integrity in our charging decisions, ensuring that we're only charging cases that can be proven in court beyond a reasonable doubt. I know now there's some issues with people being overcharged. They sit in jail for 9 months, and then when they have to make the choice to go back to their family or to take a low-level plea to get out, they're choosing the plea because they want to get out of jail. That practice needs to end as well. So consistency in plea offers and case resolutions, I think, is the first step. I mean, there's obviously other pieces of justice reform, but I think those nuts and bolts day-to-day decisions need to be revised through proper policy in Wyandotte County to start making an impact on our community and start making sure that things are fair. And I think there's far too many examples that we see across the country and within our own state and our own city of people in trust and authority who violate the public trust and undermine the relationship with the community. And that includes law enforcement officers. We've had recent charges here in Wyandotte County. I believe if there is evidence that a crime was committed by a law enforcement officer, they should be treated, the case should be reviewed and charged just the way any other case would be reviewed and charged. No one's above the law. We need to make sure that we're handling cases consistently to improve community trust. But what I really think we need to improve here in Wyandotte County is making that process more transparent. The community here often sees a big press conference, but then they don't know what happens ultimately at the end of the case. We don't get any case results as community members. And I think it's really important, regardless of what the outcome is, to make sure that our residents know what's happening on these cases involving law enforcement misconduct. If charges are declined, an explanation of applicable facts and law should be given so that people understand why that decision was made. And if there's a conviction, even if it's to a lesser charge, the community should be aware of that. I think the current system of hiding what happens in the end really undermines public trust with law enforcement.
I think it's important that you hold people, all people accountable, specifically police officers. You hold them accountable by simply abiding by the same laws. I mean, our officers do their darndest. They go out on a daily basis, putting their lives on the line, and they're trying their best to protect the community. But here's the reality. There should not be two slates of laws that are out there. If an officer commits a crime, they should be punished the same way that a non-officer commits a crime. And likewise, if I would not charge a non-officer for this crime, I shouldn't charge an officer for the crime. I think it's important that we see police officers as citizens and not ones or those who are above the law. And that's extremely important to do. But traditionally, there is this loyalty, if you will, amongst prosecutors and police officers that you don't charge them. And just historically speaking, with this administration, I've been accused of a lot of things, but that is not one. We have charged police officers. We have encouraged police officers to keep doing a great job and to do what is in the best interest. But at the end of the day, we hold police officers accountable just like we hold the rest of the citizens. So I would say yes, there are barriers. Let me say it like this. My father was a union man, and for 30 years, and I believe that unions are indeed the cornerstone of our country, and the workers have to be. Their rights have to be seen. They have to fight. However, here's the difference between a everyday worker and union, which is what my father was for all of his career, than with police unions. Police unions are indeed a barrier when it comes to holding police officers accountable. They are not simply talking about how much money they're getting and how much hours they're working and things of that sort, but they have contracts with the cities all across this country. You only have to do a Google search or a Bing search, whichever is your outlet, and you will find that there are contracts that the police unions have with cities and with the mayors and the county administrators that literally give them a different set of rules. If a person commits a crime and they're not a police officer, the police can arrest them immediately. If you're a police officer and you commit the same crime, there's a set of rules in that contract with that union that says they don't get arrested. I can draw blood from this individual, but there's a contract that says that I can't draw blood from that police officer. And so when we're talking about George Floyd, many people were wondering, well, why is he not arrested immediately? Well, there are contracts that are in place that prevent officers, right, from doing their job because these signed contract by city governments give them this additional or new layer of laws that are not constitutional. It is something that is contracted with the city. And so I think that those are real barriers, and those same barriers in those contracts. For instance, in that George Floyd situation, we know that the lead officer ends up having over a dozen community complaints, and some for excessive force and other things of that sort. Well, it was the contract with that police union that forbade that agency from releasing that information to the community. So here's the thing, maybe, just maybe, if the community would have known that they have this rogue officer who's out there getting these complaints. We don't know if he's been held accountable, if he got suspended, but we as the people can't hold people accountable if their actions are hidden. I can't hold anyone accountable if there isn't an open way for me to see these actions. And so those are some of the barriers. And then I would absolutely add on to this, and I've taken this vow to not receive endorsements or funds from the Fraternal Order of Police or the policing unions, because it is an appearance of impropriety. Here's the reality, folks. If I am being paid, if I am being financed, if I have been pushed by the police union and they're putting up my signs, they're paying for my door, not everything, guess what? When I get in here, that good old boy mentality, which has plagued the country, which I believe has absolutely caused this tipping point in our country and in our world, that thought process of I scratch your back, you scratch mine, when we get into this position of authority, I'm going to have to take a second guess on whether or not I charge a police officer or whether or not I decline to charge that police officer based on how much money and how much work they did on my campaign. I believe that every person who's running for this position should not receive those funds. And I can say that because I've never done it this time or the time before. But this has to happen because these barriers is based off of appearance. These barriers are based off of these contracts and the good old boy thought process of, if I put you in, you need to remember that, because if you don't do what I tell you and make sure you don't charge my officers, I'll take you out. And that type of loyalty has gotten our country in the situation that we're in. And if we're not careful with people who are even running down, if you are beholden to the very people that you may have to police, we'll be in that situation again.
Well, I don't. And actually, prosecutors in the state of Kansas have a lot of different tools at their disposal. They can convene a grand jury in order to investigate certain crimes if they don't feel like they've received all of the information from the original investigative file. And they also have another tool called an inquisition at their disposal. And that allows you to actually take depositions of witnesses. It gives you subpoena power like the grand jury does as well. These can be used in any case. And in my experience with the Attorney General's office in the state of Kansas, where we handle a lot of public corruption cases, those are tools that we used often in law enforcement and public official misconduct cases. So I don't think there's any barriers. It's just a matter of how a district attorney chooses to use those options. First things I'll do is revise policies to ensure that similarly situated individuals receive consistent case outcomes. And also, I will revise the bail and bond practices to make sure that nonviolent offenders don't sit in jail just because they're unable to pay. One of my other priorities is working to recruit and retain a diverse group of experienced attorneys. Retention in the district attorney's office is a real issue right now, and that directly impacts crime victims and how cases are ultimately handled. So I think that's a really important area that we need to work on. I also want to work on increasing trial advocacy training so that we can improve courtroom outcomes. Because inherently cases are going to go to trial. There's some very high level cases pending in Wyandotte County. And I want to make sure that everybody has the training and advocacy skills to make sure that we are representing Wyandotte County effectively in the courtroom. I also want to work to improve the conviction integrity unit to ensure that there is an independent review of cases that isn't subject to influence from either trial prosecutors or defense attorneys. I really think a neutral review of the evidence of cases that are post-conviction is really important to making sure that a fair decision is made. And I also want to improve the transparency of that unit so that everyone knows what's happening. And that includes crime victims. They shouldn't have to learn from a news release that their loved one's case is being reviewed. That's completely unfair. But also for the families of individuals who are incarcerated, if they're filing petitions with that unit, they deserve updates because obviously their loved one is seeking relief and they deserve to know what's happening as well, as does the community. So I think transparency in that unit is also very important.
I will continue to make sure that this office does not go backwards. Before I got into this office, there was a noose that was being passed around. Whenever individual attorneys would win or rather had a hung jury, and it was a locked jury, the lead attorneys would then go and put a noose on the desk of the assistant district attorney who was in that trial. The culture in this office was so that it was okay for that to happen. There was a lack of cultural competence. And so I don't believe that an attorney can call themselves legally competent without being culturally competent. At those times, there was only one African-American lawyer in this office, maybe two. And then ultimately, they're in the office with the news being passed around. What do you say to them? How do they feel knowing that 5,000 African Americans were murdered and hung and lynched in this country by nooses, but this is a tradition in the office of the chief law enforcement official? We changed that. We got rid of the news. We got every person in this office, every attorney, every staff, implicit bias training, because it's important that we understand other cultures. If the only people you can police or prosecute are the people that you know, there's a problem. We got the implicit bias training. We brought in diversity. We now have one of the most diverse district attorney's offices in the region and definitely within the state, with more than 5 African-American attorneys, a Hispanic attorney, Asian attorney, because I believe that the office should look like the community that it serves. We changed the officer-involved shootings that result in death, and we bring in that independent investigation. We created the conviction integrity unit, looking at those old cases. We created the youth mentoring program and engaged our young people, and we continue to engage our community with the liaison board, the youth mentoring, and then when folks are coming out, we created the reentry program so that we can assist in making sure they get their record expunged and get a job. And so what are the things that we will do? We will continue to make sure we don't go backwards. What was will never be again unless we bring back the old. We have to keep moving forward with holistic prosecution, looking at every case based off of the facts of the case. One of the biggest things that we deal with, we get a case and then people decide they don't want to cooperate, evidence disappears and things happen, and we have to deal with that and make the determination. Do we still go to trial, or do we figure out how to get something out of this? Do we plea something out? These are things that we now take a hard look at on a case-by-case analysis versus one shoe fits all. This case gets all pleas. This case gets a certain amount of time. That doesn't work. We've made substantial change. We moved Wyandotte County forward, and we're going to continue to do that and keep moving this county forward.